Hi, welcome to this week's With Liberty and Justice for Some. I'm Congressman Mark Pocan. With me today for one question is a constituent, a Madison, Wisconsin resident who writes not only for our local newspaper, the Capital Times, but is the executive editor of The Nation magazine nationally. It is our good friend, John Nichols. Welcome, John.
It's a pleasure to be with you, Mark.
All right, John. So I have one question for you. If you could change any one law, either implement something new or get rid of something, whatever you want, because you don't have to go through Congress. You don't have to have Mike Johnson support it. You don't have to have, the Freedom Caucus say anything about it. You could just make a change. What would that one change be and why?
I'd get rid of the Electoral College. And I would do it because, there are many laws. Look, we could go forever, but I tend to be a structuralist. I'm very, very interested in the structures of our politics and what gets in the way. And the Electoral College has left us repeatedly with presidents who did not have majority support.
Today's podcast is going to focus on an area where we've had some of the most success pushing back against the current Trump administration, but how that success could quickly slip away without some powerful organizing around it. And I'm talking about the courts. Specifically, I'm talking about some of the court appointments that occur that can really affect us in some very profound ways. We know that when someone gets a selection as a federal judge, for example, those are often lifetime positions. Having fair, impartial justices who understand the legal system and want to see it fairly executed is a priority for everyone. Unfortunately, too often we see right-wing groups like the Federalist Society and others that our guests will probably know advocating for jurists with extreme leanings to get these lifetime court positions. Fortunately, as a counter, we have groups trying to make sure that those extremists don't get on the court. Groups like Demand Justice. Demand Justice is a progressive advocacy organization committed to fighting for federal courts that protect rather than dismantle the rights of working people. And that group just got a new president, someone who I've known for a long time and has strong Wisconsin roots. Josh Orton is a man with a lot of high-level political experience. Most recently, he was a senior advisor to the vice president, Kamala Harris. Prior to that, he worked with U.S. Secretary Marty Walsh. In 2020 presidential campaign, he was the national policy director and senior advisor to Senator Bernie Sanders. In addition to a lot of other positions that he was senior policy advisor and other titles, he worked with Senator Russ Feingold in his 2016 campaign from Wisconsin. He's a UW-Madison Law School graduate and a friend. Welcome to Josh Orton. Josh, thanks for being with us.
Congressman, it's so great to be on. Thanks for having me.
Yeah. So, I mean, that's quite a bio you got going, by the way. I mean, I've known you for a long time and I've known you have kept getting these great positions and doing great jobs in them. Glad to see where you're at now because it's so important. Can you just tell us a little bit about Demand Justice in your words and about your organization?
Yeah, sure. So Demand Justice was essentially formed during the Trump administration to fight back because we know that as you mentioned, the Republicans have been building institutions, and they are essentially over a generation ahead of Democrats and progressives in fighting for the courts, right? We know that institutions like the Federal Society, run by a guy named Leonard Leo, have been raising conservative lawyers since they've been pups, all the way, through their corporate careers, and then, essentially establishing a bench of very hard right, pro corporate, very hard right, extremists who essentially every Republican president going back a ways, they rely on the Federal Society to sort of feed them candidates to be nominated to the judicial bench. And so it's not just they've been ahead of us on the infrastructure, but they've been ahead of us on essentially the organizing, right? I would argue that the base of the Republican Party has been activated and has sort of cared about taking over the courts for a very long time. And I think only recently, really, and I think that we all have to take some responsibility for this, has our side really been engaged on court fights. Obviously we'll protest when there's a Supreme Court nomination here or there, but look, corporations have been donating to the Federal Society for a generation because they have almost like a fiduciary responsibility to try and get as pro-corporate a judge on federal benches across the country as possible, because, you know, they don't want to pay for their pollution. They don't want, you know, they want to abuse workers' rights. And so it is to their benefit to have these right-wing judges on benches. And so Demand Justice was formed, you know, in the sort of the wake of the first Trump administration, or actually during the first Trump administration, because I think there was in some ways there was sort of a deficit in sort of small p politics on the Democratic side, talking about how, look, if the federal bench, if, you know, from the Supreme Court on down, the circuit courts, the appeals courts, if these are institutions where our rights will live or die, where the progress we make in extending overtime pay to workers, to making sure we transition to a clean energy economy, when all, you know, if that progress lives or dies at the federal courts, we got to get in gear and actually fight for these things and talk about it as if, you know, we, you know, our sort of political future, you know, relies on whether or not these courts have independent, you know, fair-minded jurists on them, or whether they have, you know, very corporate friendly, very sort of extreme right, sympathetic judges from the Federal Society. And so you know, I think Demand Justice, more than any other group, came on the scene to sort of be the sort of like leading voice in being aggressive in talking about not just how we had to fight, but in proposing reforms that may not be mainstream ideas at the time, but we knew needed to happen in order to sort of retake the courts to become more fair again.
Fiduciary responsibility. I like that.
I mean, essentially.
Yeah, no, it's an accurate and well used use of words. So your organization in the past has led on some of these fights against the confirmations of Brett Kavanaugh and Amy Coney Barrett, right? And as well as you've advocated for folks like Ketanji Brown Jackson. And tell us more about the role that Demand Justice is taking at that level, even though there's other levels we're going to talk about at that Supreme Court level.
Well, I think one of the, you know, seeing the whole sort of playing field, you know, I think the one of the real value, some real value that Demand Justice can contribute is to essentially sort of stake out positions that we know to be the right positions, even if maybe they haven't yet been accepted by the rest of the party or in the mainstream yet, and work to move the conversation towards those positions. And I'll give you a couple examples. You know, it was Demand Justice that was one of the first groups to advocate for expanding the Supreme Court, adding more seats to the Supreme Court, to talk about jurisdiction stripping. So to actually raise questions about, well, maybe the federal court shouldn't have the ability to strike down some of these laws or regulations that protect people. And at the time, and I remember because I worked for Bernie in 2020 when Demand Justice had its presidential forum, you know, it was, you know, in Bernie's words, somewhat of a radical proposal, expanding the Supreme Court. And I think what we've seen since is sort of the theory of the case here, which is that at the time, 4 or 5 years ago, what seemed like a radical idea, in the years since, and I think partially based on just the Supreme Court's behavior, what looked like a radical idea at the time, expansion, now looks way more reasonable. And it's moved that we've sort of, the party and sort of the mainstream conversation has moved towards that idea. And I think Demand Justice has this unique role where we can propose what we think should be the solution, even if it's a little touchy at the time, even if it's not a well-established popular idea at the time. Another example is in the sort of in the affirmative case, when President Biden won election, Demand Justice called for the incoming Biden administration to not nominate a single corporate lawyer to the federal bench. Now, that was Demand Justice's position because we thought that was the right thing to do.
Yeah.
Did the Biden administration sort of take that advice and not nominate any corporate lawyers? No. However, I think the Biden administration was savvy enough where the fact that we sort of raised the question of, well, what is the value of a corporate lawyer on the federal judiciary? And maybe we should rethink sort of the default thing that everyone always does, which is we look at these, what we consider very well qualified, you know, white shoe corporate lawyers who've defended corporations or very, you know, in sort of come from a very elite legal community as the sort of standard for a judgeship. And I think by calling for that, Demand Justice opened a conversation of, well, what maybe there would be value in having public defenders sitting on the on the federal bench. Maybe it would be of value to have a civil rights attorney or a voting rights attorney like we have in Dale Ho, who's now sitting in a sitting judge at district court in New York. And so demand justice has this role to sort of say what should be, even if it's not necessarily what everyone agrees with at the time, and then moving in that direction. It's, to sort of push for progress.
So let's talk at the beginning. You mentioned a couple of the reforms on the court that you guys have advocated for. A couple of them, I think that I hear the most. One is definitely adding to the court, and if you could talk a little more about that, plus maybe just that throughout history the court has changed. I think a lot of people don't know that. And then secondly, I know some people have talked about term limits for the court. Could you just talk about a couple of those ideas? I'm curious where you all stand on that.
Sure. And I think, what I think is on expansion, I think what is a sort of a first fundamental fact is that the Constitution does not dictate how many Supreme Court justices there need to be, right? And so the fact that there are 9 is something that sort of is established by law, but Congress can determine that, right? Congress has a lot of power in shaping both the scope of the federal judiciary and what things it has jurisdiction over, but also what it looks like. And so it is perfectly legal and perfectly constitutional for Congress to say, well, you know what? We've seen the Supreme Court essentially not be bound by any ethical code. We've seen these justices sort of go on these corporate sponsored trips on these private jets to these sort of, to these boondoggles, right? And then turn around and oversee a case where some of those same interests are represented in their courtroom in the Supreme Court. We've seen these people over and over again, the sort of Roberts hard right Supreme Court rule consistently over and over and over again for the expansion of power when it benefits Republicans. Maybe at this point, because we've gotten to this Supreme Court that is sort of so gridlocked in partisan power and seems so aligned with corporate interest, that we need to expand so there's more seats to sort of mix it up a little bit so that the Supreme Court maybe becomes a little bit more representative, not only of the American populace, but of sort of ideologically more oriented towards protecting fundamental rights for people and less about protecting corporate interest and sort of far right religious views. So that would be perfectly legal. It would be perfectly constitutional. And I think, like I said, when this was proposed a few years ago, I think it boggled some minds just because everyone, in their lifetime had, heard of 9 Supreme Court justices, the 9, this is what they know of. But it's not been the case. And I think one of the analogs that is sort of useful to internalize is, we sort of think about the Senate as having always been this institution that has a filibuster and that, that sort of protects what are supposedly the minority rights of the rights of the minority party. But of course, the rules of the Senate are fluid and have changed many, many times over the years. The Senate can sort of set its own rules. And so just because the Senate rules are the way they are now, because that's what we know, doesn't mean that's how they've always been. And it doesn't mean that it's always how they have to be. And I think when we think about expanding the court, it's the same thing. We'd have to, obviously, Congress would have to act. And I think, there's a couple other ideas about, when I talk about jurisdiction, I talk about, well, the federal courts get to decide cases essentially based on what Congress says they have jurisdiction over. And so jurisdiction stripping could be a way of looking at the cases. You see so much progress, and in the Biden administration was a great example of this, of all of this, especially economic progress in terms of things that would put billions of dollars in millions of people's pockets, just sort of halted at the national level because of some federal courts. And so there's a question of, well, when it comes to sort of voting rights, or when it comes to certain, regulations that help people economically, or sort of hold corporations accountable, what is the role that federal courts should have in being able to stop those things? And so that's an open conversation. And I think one of the interesting things that's going to happen over the next few years is that, I guess we don't really know the extent of the damage that Donald Trump and his administration will do, both to the administrative state, to the regulatory agencies. Obviously, he's done a ton already, and to the rule of law. And so I think one of the roles that Demand Justice is going to have in the next few years, and in cooperation with other allies, with the grassroots, with elected representatives, is essentially thinking, well, what would post-second-term Trump reforms look like to make not just the court more representative to the people and more aligned with protecting people's rights, But what do sort of age, what should they have what are the federal courts, what should they be able to rule or overturn in general? Because I think what people have seen, not just in striking down individual rights, and we saw the Supreme Court hear a case that would essentially overturn the remainder of the Civil Rights Act, and the Voting Rights Act,
Yeah.
is the Supreme Court has essentially enabled the slide towards oligarchy. Just a month ago, the Southern Fifth Circuit, heard a case where Elon Musk's SpaceX was suing the National Labor Relations Board, the independent agency that essentially enforces worker rights, that enforces the right to form a union, that makes sure that union elections are fair and safe, and the corporations don't hold captive audience meetings and sort of intimidate their workers. Elon Musk sued, and through his ridiculous space company SpaceX, to say that all of the NLRB is unconstitutional, like just generally. Yeah. And the Fifth Circuit, it was a ruling by a first-term Trump judge, said, yeah, it's unconstitutional. And what I think is interesting is that we've heard barely a peep about that from either the media or from anybody on our side. Yeah. And the idea that in this era where there's such wealth and income inequality, that the NLRB as an agency could be ruled unconstitutional because Elon Musk says so, and then there's very little we could do about it, to me is outrageous. And so I think another thing we have to focus on when we're looking at these reforms is, how do we stop these courts from enabling oligarchy the way they've done?
Yeah. So you got a lot there, and there's a lot we can do with the courts.
Yeah.
Let me go back, because I think this is one that it took me a while to really understand. I mean, we've changed the Supreme Court in size, and I agree. I think, to me, that is a better change than the term limits. Personally, I think that, affecting the size, but we've changed it multiple times, right, throughout history. Yeah. It's not like 9 is what you and I know, but it's changed, I think more than a handful of times or something like that.
Yeah, and of course, FDR, proposed expansion to 12, right? It was sort of, remember the whole, I don't remember the whole case of the switch in time that saved 9 in order, he essentially, what was interesting is sort of it has changed a lot, and also the size of it. We think of the Supreme Court as this sort of sacrosanct, static institution where nothing has changed. And I think what you saw was, FDR proposed an expansion of the Supreme Court. I think it was an earnest proposal, but it also was a political proposal, right? Because he was attempting to sort of use his leverage of expansion to push the Supreme Court to be more representative. And I think, so yes, it has changed multiple times. Yes, it has not always been 9. I think there's I certainly don't think we should shrink the Supreme Court. I think we should definitely make it more representative and increase the number of justices. But I think that I don't think there's any norm or precedent or law or really even, or anything that would stop us from doing that. And I think it's a question of how many justices, how many seats do we think we need to add? And honestly, I think that's going to come down to what do things look like in a couple of years? And how has the Supreme Court essentially unilaterally given power, not just to the Republican Party, but we're seeing cases like the tariffs case we saw with the immunity case when Trump was out of office, that essentially handed unlimited power to Trump himself. And I think one of the things that is really hurting the legitimacy of this court is, you saw there, we heard the oral arguments in the voting rights case, and it sort of looks like the court's inclined to overturn that. We heard the oral arguments in the case that the law in Colorado that would ban conversion therapy for kids, gay conversion therapy for kids, which is obviously an outrageous practice, and sort of their warping of the First Amendment to do that. And, there's a sort of stream of cases where we sort of expect the Supreme Court to continue giving away power to the religious right and to the Republican Party. But I think the thing that will ultimately really harm the credibility of this court is when it gives away unlimited power, not necessarily just to a party or to the far right, although I think that desperately damages their credibility, but is when they give away unlimited power to Trump because he wants it. And I think that was the case. I think that was the case with the immunity case, and I think that may well be the case with the tariff case coming up.
Yeah, so let's talk about that one, the immunity case. I think I hear that a lot. Whenever I do a town hall, inevitably it'll come up to this general issue or this very specific issue about what the courts did. Can you talk a little more about that case and what we can do about that?
Yeah, well, it's interesting because I think one of the things that what Trump was essentially arguing is, and this has come up with a string of corruption cases. We saw this with a corruption case against a former Virginia governor. We saw this actually come up in the first trial of former Democratic Senator Bob Menendez in New Jersey. Is that the federal courts over time have essentially, let's say, not want to say legalized corruption, but decriminalized corruption in a way.
Yeah.
And because they've interpreted anti-corruption laws to be narrower and narrower and narrower. So essentially, if you don't have like a picture of a guy holding a suitcase and shaking hands, handing over a thing of money, it's almost impossible to indict, to sort of convict someone on corruption charges, or elected officials anyway, on the federal level. And I think what we saw with President Trump in this immunity case went even beyond that, because what this is sort of fits a pattern in Trump, essentially in his sort of authoritarian view, right? We saw for years, and we saw this, together under the George W. Bush administration, that there was, Republicans always want the most expansive idea of executive power because it means they can do as much as they want. We saw this happen in the war on terror with expanded powers. Obviously, our friend Russ Feingold was one of the champions in pushing back against executive power, even when it wasn't popular in either party.
Yeah.
And I think that Donald Trump sort of took this to this ridiculous extreme, where it wasn't necessarily, it wasn't about something he wanted to do officially as president. It wasn't about, he wanted to illegally, expand the policy, to prosecute the war on terror. He didn't, it was not related, as sort of quaint as it seems, to something that he actually wanted to do as president, even if we all disagree with the constitutionality or legality or morality of it. It was about him personally. It was about his ability, as president, to essentially try and overthrow an election, right?
Yeah.
And his case here was essentially one where if he hadn't sort of won that case that granted him this sort of, that expanded what presidents and then former presidents could be charged with criminally for things they did as president. That's the thing that it basically constricted what ex-presidents could be charged with for the things that essentially they would argue were related to their official acts as president. He would have probably gone to jail. Would have probably gone to jail for his role in trying to overthrow the federal government on January 6th. And so I right, yes, that's right. And this comes up, and actually will sort of come full circle to some of the judges that the people he's nominating to federal judgeships now, and the things he requires them to say to get the job about January 6th and about the 2020 election. But I think one of the reasons I think that expansion of the Supreme Court is so necessary now is it's not just the sort of rampant conflicts of interest that we see, with their alignment with sort of these corporate powers. It's that this Supreme Court basically gave away presidential power to Trump, and it's going to stay expanded. It basically decriminalized a whole bunch of conduct of a president. And until we change the makeup of the court, our democracy is going to essentially limp along injured, because the president can, if they make an argument, break the law during office and never be held accountable for it.
Now, another case you brought up was that voting rights case. And I think last week when I was in Washington, I know some of that was front and center in the national news. Can you talk about what's at stake with that decision?
Yeah, I mean, this is, we've seen the Voting Rights Act be whittled down and down and down over the years from its height. And I think essentially what it comes down to, and this is a similar argument that was used to strike down other elements of the Civil Rights Act, is, the Civil Rights Act, the Voting Rights Act was, established because of racism in how it affected voting rights, right? And whether or not minorities, especially Black people, would have sort of full voting power in not just individually, but in representation in Congress, right? As you know, right? And so the question is, can lawmakers take into account the dilution of the voting power of historically disadvantaged minorities when constructing political, congressional districts, because otherwise, if they don't, that lawmakers can essentially dilute things to the point where there are no majority minority districts, right?
Yep.
And I think the thing that came up in the oral arguments that's come up before is the thing that it's sort of like the same argument that everybody's uncle makes on Facebook over and over again, except it's coming out of the mouths of Supreme Court justices, which is like, well, when is racism going to end? Isn't racism over, right? Haven't we done enough to sort of right these historical wrongs? Racism is over. You elected Barack Obama, right? All these sort of hacky, arguments. And this came up too in the Supreme Court, which is they're sort of making the sort of conservative justices who are opposed to this last vestige of the Voting Rights Act are essentially arguing, well, if you can't tell us a defined end date for when racism is going to end, and that we no longer have to sort of make sure that Black people and minorities we allow policies to give them full voting rights and full political representation, then we can't have any rules that will make sure that they have political representation and full voting rights, because you can't tell us what it will look like or when racism will end. Isn't racism over already? Hasn't racism changed over the years? And I think one of the problems is that, culturally, I think we've seen, the Supreme Court, I think, is limited in its rulings by what is sort of acceptable culturally, even if it's on the far right. And I think what we've seen is that the Supreme Court is looking at this case and thinking to itself, well, we can make a fairly cynical argument about how racism has essentially been diminished for so long, and no one can really tell us how to define when it will be over, that we think we have the ability to sort of overturn this because, no one will stop us, and it will seem outrageous for a little bit of time, but ultimately it's going to embolden Republicans. It's a giveaway for Republican power.
Big time.
And I think one of the things that as people on the left, as progressives, that we need to sort of accept is the Supreme Court. And I know that we sort of know this academically, but I think we have to sort of really internalize it in sort of how we advocate. The Supreme Court is not making intellectually honest arguments. I know that seems like the most obvious statement in the world, right? but they're trying to get to an outcome that will help grow Republican power no matter what. And so they will find whatever, and this is sort of the end game of the Federal Society to begin with, is they raised essentially very brilliant legal minds who are at the same time fairly brilliant political strategists, right? And so their role is to be able to come up, sort of backfill legal, intellectual, complex arguments in order to get to a political result. And I think that's what's going to happen with the last vestige of the Voting Rights Act, is they're going to come up with some, half-baked intellectual argument, but really what they're trying to do is give more power to the Republican Party for generations.
And right now, how the congressional branch of government is not standing up to the executive branch of government. If you don't have the check and balance of the courts, I mean, this is where it all hits. One last question.
They're trying to rig them. They're trying to rig. They're trying to rig it all around.
One last question on the Supreme Court, specifically ethics. We saw some high-profile, interesting, and I'm saying that very loosely as I wave my fingers around the word interesting. Things happen ethically, especially with Clarence Thomas and some others on the court. Do they even have ethics rules, substantial rules in place compared to other federal officials? Can you just talk about that?
Yeah. So for a long time, while lower courts like circuit courts and district courts had a binding code of ethics, where it wasn't just that they had to sort of, that they had to report conflicts of interest, but they had an obligation to sort of recuse themselves. The Supreme Court had no binding code of ethics at all. And I think John Roberts, who I think has done a sort of a cynical job attempting to preserve the court's legitimacy in the face of this, proposed, I wouldn't say it was a binding code of ethics. I would say it was a voluntary ethical list of ethical suggestions, right? To basically say that Supreme Court, justices that was sort of kind of mirrored the binding code of ethics that lower courts had to follow, but there's really no enforcement mechanism and there's no consequence if they violate them. And so the answer is they are pretending to have a code of ethics now, but it's really never been binding. And so that's another thing that I think it would be an incremental reform. I think we have to go a lot bigger than a binding code of ethics for the Supreme Court. But I think at a bare minimum, it's really hard to disagree, no matter what party you're from, no matter what ideological background, that as Supreme Court justices, they should be bound by the same code of ethics with consequences that everybody else is bound by.
Yeah. So a couple times we brought up a little bit of this other process of a nomination of federal judges.
Yeah.
And, we saw some very interesting people being nominated under this administration already. We know there's things like blue slips people hear about, but they don't necessarily know what that means. Give us a 101 of this process of how people get nominated, how they get appointed, who they are, and why does it matter to the average person?
Yeah, for sure. And it's a little convoluted, to be honest, right? It differs a little bit by state. So this is a process that, as you know, the power is entirely in the Senate. In terms of if Congress is involved, to the extent that Congress is involved, it's all the U.S. Senate, right? Because they are they have the advice and consent role dictated by the U.S. Constitution. And there is a lot of both. There are norms and practices that give a whole lot of deference to home state senators, and it sort of happens on two levels. First, a lot of times, and I think Wisconsin is one of these cases where there is essentially a body that comes together and gives a list of recommendations of federal judges, and it is bipartisan, right? This sort of body gives a list of recommendations of federal judges that then, in theory, the senators then pass on to whoever the incumbent administration is. And, once you have that sort of list of people, then essentially the administration will nominate one of those people. And this is where sort of the second level of deference to home state senators comes in. This is where this practice of the blue slips. So let's say, Jane X is nominated from Kenosha, Wisconsin. She's been a longtime lawyer and she's nominated to a federal judgeship. She's a hardcore Republican. She's, made troubling statements on reproductive rights in the past. She's, talked about how corporations are people, really troubling stuff, right? If they're nominated, both senators, both Ron Johnson and Tammy Baldwin, have to essentially return, because it's literally a blue slip of paper, a blue slip saying, yes, I approve of this nominee. And the chair of the Senate Judiciary Committee, Chuck Grassley or whoever it is, historically has honored those blue slips. And if one of the two senators doesn't return that blue slip, that nomination, in theory, doesn't go forward. Gotcha. Now, normally that has happened for a long time, and I think the Republicans have sort of played this game where they have talked about how important the blue slip process is, that deference is to home state senators, when it benefits them, when it is when they want to stop a potential nominee from becoming a judge. And so at times the Republicans have sort of ignored the blue slip process when it's sort of a nominee that's very important to them. I would argue that when Democrats took back over and then Senator Leahy was the chair of Judiciary and brought back the blue slip system, I would argue that perhaps it was predictable that once Republicans took over, it might be abused once again, which it has been. Now, Grassley has sort of worked to uphold the blue slip process, this deference, to Trump's chagrin, right? Trump has actually been very vocally frustrated with Grassley because he sort of allowed this deference. But, I think it will exist so long as Chuck Grassley and the Republicans in the Senate stand up to Trump, but I don't think it's going to last forever, right?
And he just made a pitch this week, right, with senators to get rid of from Trump directly.
That's right. And so once so let's assume that both senators return the blue slip. Then these nominees will go through, they go through an FBI background investigation. The stuff goes to the Senate Judiciary Committee. What's interesting is historically the slate of nominees has been announced by the White House far in advance. And this is where the process has gotten much different in a second Trump administration, right? So Trump, as we sort of talked about before, in his first administration, did the thing where he essentially outsourced the nominating process to Leonard Leo and the Federalist Society, as George W. Bush had, as George H.W. Bush had before him. And I think, and what's interesting is that this term, and it was towards the end of April or May this spring, Trump had sort of unilaterally enacted some of these tariffs, and the International Court of Trade, one of his nominees that he had confirmed in the first term, ruled against him on tariffs.
Yes.
And Trump was furious because I think, and he sort of, he said that he criticized Leonard Leo and the Federalist Society publicly. He said that Leonard Leo probably hates America, that he gave him that Leonard Leo gave him terrible advice on judges in the first term. And I think what happened is, Trump nominated and got confirmed a bunch of pro-corporate extremists on all kinds of federal courts. But what he realized this spring is that those judges weren't personally loyal to him. Right. And I think for Donald Trump, that is like the biggest betrayal is that if someone that he gives political power to, whose career he advances, if they are not personally loyal to him. And so we saw the process change. And so now Trump is announcing every nominee for federal judgeship himself personally on Truth Social, endorsing them personally. And what is clear is that he is now approving of every one of these people. He is not going to make the same mistake twice and just trust that if they're extreme and if the Federalist Society says they're good, that they're good. He doesn't look in the final analysis, Trump is a hard right Republican in so many ways. But, if it's a choice between something that benefits him versus something that's true to the ideology, he's going to choose something that benefits him, right? 3 minutes ago, Republicans were anti-tariff, right? And so now he's blowing up the Federal Society because one of the judges he confirmed in his first term voted to block his tariffs. And so he's now handpicking these people. He's personally announcing them in his voice on Truth Social. And he's now essentially giving them a political litmus test. Every single judge that he's nominated, one of the things they have to do to get his stamp of approval is they have to propagate his lie in the 2020 election, and they have to lie about what happened on January 6th. And every single one, either orally in a hearing out loud or in written responses to questions that senators give, they've all essentially non-answered those two questions with almost identical language. And what it tells us is that the White House essentially gave these nominees answers to who won 2020 and what happened on January 6th. They gave these nominees language that they knew that Donald Trump was okay with. And that was the most that they could say. So, for example, there was a nominee, Kyle Dudek, who was confirmed to the Middle District of Florida. When asked about 2020, he wrote, "This question draws a legal conclusion about the events of January 6th, and I am aware of the legal import of pardons issued to these prosecuted for involvement. Thus, as a current judicial officer, it would be improper to offer any further comment beyond that I condemn violence." It's like that. If you asked a normal person what happened on January 6th and they said that, you would like, did you turn into a robot? Right? And every one of them about the 2020 election says, well, technically, the House certified Joe Biden as the winner. Like, that's not an answer, right? Because if these people were asked in a hearing, if let's say Peter Welch or Sheldon Whitehouse or any of the Dem senators on judiciary asked these nominees point blank in a hearing, who lost the 2020 election, and they said Donald Trump lost the 2020 election, we all know that their nomination will be yanked the same day. And so in our view, every one of these judges, because now Trump is picking them to be political cronies and forcing them to essentially propagate his lies on these two events, every one of them is politically compromised. Every one of them has had to essentially sell their professional soul to be nominated for a lifetime appointment on the bench by Donald Trump. And if you think about the consequences of that, I know we're sort of going a little further into this, you saw Donald Trump is now enacting revenge prosecutions against his political enemies. He's now ordering the National Guard from one state to invade another state, illegally. Imagine if one of these judges was nominated to oversee the revenge prosecution of Comey in the Eastern District of Virginia, when we know this hack Lindsay Halligan is prosecuting. Like, you really want a judge overseeing that case who can't say who basically refuses to say who lost the 2020 election just to curry favor with Trump we've got a banana republic at this point. And so one of the concerns that we have is that some of our friends in the other chamber on the Democratic side are now voting in favor of these Trump judges. And we think it sets a pretty dangerous precedent, both historically, morally, and because we don't think any of these judges are qualified at the time where Trump is weaponizing the DOJ and using the system of justice to his own political and financial benefit. None of these people, if they have to take a political litmus test to be a Trump nominee, they are not qualified.
No, these are not normal times, right?
No.
the bottom line everyone has to remember. Hey, thanks, Josh, so much for being with us. And I'm so glad that Demand Justice is there doing the work you're doing. And maybe I'm glad the Federalist Society is getting a little bit of right now. That's probably
a little blowback.
Right. We'll take that. How do people follow you, Josh? How do people follow Demand Justice if they want to know more about what's happening with our courts and all the other work that you're doing?
Yeah, please. It's demandjustice.org. And you can see we have trackers of who Trump has nominated, what their records are, who has or has not voted for them. You can sign up for our list. We have sort of a couple different entities that demand justice, so we can do advocacy. We can, eventually towards an election, get involved in political work. It's demandjustice.org. We can sign up. I'm just my name, Josh Orton, on Twitter. We Demand Justice is where you can find Demand Justice on Twitter. And, we're in this for the long haul because we have to essentially stand up to Trump now. But as we were sort of talking about, we've got to sort of figure out how to reform the system in the long term. And so this is a short term and it's a long term fight.
Yeah. And I'm glad you're there. Thanks, Josh, so much for being with us today.
Thanks, Carmen. Thanks for your work.